I'd like to briefly talk about a recent legal case in the USA that could have significant influence in the Australian courts. It's commonly known as the Halliburton case. This case is about the fraud on the market concept, which presumes that in an efficient marketplace, a company's share price reflects all publicly available information about that company, including any alleged misrepresentations made by its management or board of directors. This presumption allows plaintiffs in US securities suits under Section 10B of the SEC Act to seek certification of a shareholder class without having to show that each one of the shareholders relied on a specific alleged misrepresentation. Essentially, it makes it easier to form a class in order to bring a class action. Without the benefit of this fraud on the market presumption, it would be a lot harder for claimants in the USA to pursue their claims as part of a class action. However, if we were to set aside the fraud on the market presumption, the D&O claims landscape would be significantly changed. Underwriters consistently assess the potential for US class actions as one of the higher D&O risk types, and with no fraud on the market presumption, we would need to re-evaluate this view. US securities class actions would change dramatically, as each individual shareholder would need to pursue their grievance individually, which is a cost-prohibitive, inefficient method to seek damages when multiple parties have allegedly been wronged. This whole issue of fraud on the market raises the question of whether or not the stock market is as efficient as presumed. The appropriate question should be, has the alleged misrepresentation actually affected a company's stock price? Cue the Halliburton case. It became a recent test of a 1988 decision made in the Basic case. Halliburton looked to overturn the fraud on the market presumption. Can investors trust the efficiency of the stock market when making a decision to buy or sell a stock? So what does this mean for Australia? Well, Australia is a close second to the US when it comes to securities actions versus companies and their management teams. And like the US, Australian class actions can be founded on allegations that public disclosures made by a company and its directors have been misleading, deceptive, or in breach of directors' obligations. We've seen a number of such actions in recent years, and we expect that it won't ease up anytime soon, especially as the litigation funding model matures further. The fraud on the market presumption may not have yet had an active consideration in Australian courts, but we think it may only be a matter of time before the courts contemplate the issue. In Catlin's recent newsletter that can be found on our website, we have included a paper on this important case and its implications for companies and their insurance advisors. Please stay tuned for updates, as this issue is a developing one, and recent Australian cases are more carefully considering the practicalities of bringing securities class actions in this country.